Hello aspirants, I am Velan from Keystone IAS Academy, and this is SPS Sprinter Prelims Stimulator, a pre-initiative of Keystone IAS Academy. So this is our second test. So in this test, we majorly deal about polity with the current affairs. The first question that we see is, consider the following statement regarding role of governor in Indian federal structure. Okay, well, Indian federal structure we can use various terms to refer because Indian federal structure is not absolute. We can say Indian federal structure as a quasi-federalism and cooperative federalism in a various names. So in this respect, governor plays a major role with respect to state administration. So the first one, the governor acts as a constitutional head of the state but hold office during the pleasure of President of India. This is a correct statement because there is no such fixed tenure for a governor. He holds office during the pleasure of President. Moreover, he acts as a constitutional and nominal head of a state government. The second one, the power to reserve a bill for consideration of a President exercised only on the aid and advice of a council of ministers. This is incorrect because if a bill is reserved for the consideration of a president, it's full discretionary power of a governor. It's not depend on aid and advice of a council of ministers. The third one, the governor report to central government regarding the breakdown of constitutional machinery in the state is prerequisite for the proclaim of a president rule. This is also incorrect because the proclamation of a president rule in a state government is not only depend on the governor report, it based on some other agencies too. So this is incorrect. The option is option A, one only. And the second one with reference to delegation of an executive function. This is important term. Between the center and states in India, consider the following statement. They gave two statements with regarding delegation of executive functions. The first one, the president can entrust executive function of a union to a state government only with the period consent of state government. So this is very simple because if you delegate something to someone, mean they have to accept first, then only we can delegate. The same thing apply here with the period consent of a state government. This is a correct. The parliament can delegate the executive function of a union to a state government without consent of a state. This is also correct. So answer C, both 1 and 2. The third question, under the Indian Constitution, who is empowered to place a union territory under the jurisdiction of a high court of a neighboring state? As we know that there is a constitutional article 241 which majorly deals about high court of a union territory. So in this respect, they are asking the jurisdiction of high court in a neighboring state. For example, we know the territory of a Pondicherry, which is under the jurisdiction of a Madras High Court. It's mainly under Tamil Nadu. So in this respect, the option A, Parliament, is a correct answer. So in the fourth question, they give types of bill in which how many of the aforesaid bill require the period recommendation of a President of India before the introduction of a Parliament. So they give three types of bill. The first one, a bill that imposes or modify any tax or duty in which state have an interest, which means any tax or something else in which state has a stakeholder, which act as a stakeholders. So we can say this is a correct because whatever the bill that affect the state interest which require period recommendation of a president. And then the second one, a bill that alter the definition of agricultural income. As we know that agricultural income is a subject of a state. So in this respect, which require period recommendation of a president. The third one, a bill that levy surcharge on the purpose of a union government. If you are taking a surcharge or cess which is exclusively the subject of union government, in this respect the president recommendation not necessarily obtained before the introduction of a parliament. So option B, only 2. The third one is not in the list. The fifth question, which deals about office of president. The Vice President of India is modeled on the basis of a US Vice President. In this respect, they gave a two statement. The Indian Vice President office is structured on the model of Vice President of United States. This is a correct statement. The second one, unlike the Indian Vice President, United States Vice President assume the office of President upon vacancy and serve remainder of a predecessor term, which means that if any unforeseen, it may be a vacancy happen or a death happen, the remaining term in which the Vice President act as a President in a full capacity, unlike Indian situation. While India, the Vice President only act as an acting President, on the contrary to US, the statement both 1 and 2 is correct. And the sixth one, which deals about cabinet committees of a union government, in which they gave a 3 statement. The cabinet committee on political affairs is the most powerful committee, often dubbed as a super cabinet. This is very important because, as we know, there are n number of cabinet committees. Among them, the cabinet committee on political affairs headed by Prime Minister, which is often dubbed as a super cabinet. This is a correct. Then the second one, the cabinet committee on parliamentary affairs deals with the legislative program of the parliament and determine the government stand on non-official bill, which means which might introduce maybe a private member bill. In this respect, this is also correct because the cabinet committee on parliamentary affairs determine those things. All cabinet committees, including both standing and ad hoc committee, necessarily headed by the Prime Minister. So it's not necessarily headed by Prime Minister because some committees are headed by Home Minister and then Minister of Parliament Affairs, so not necessarily. So the option A, 1 and 2 is correct. And the seventh question is a statement based question. In the context of constitution provisions governing size of the Union Council of Ministers, consider the following statement. There are 2 statements. The statement 1, the total number of ministers in the Union government, including the Prime Minister, which including the Prime Minister, shall not exceed 15% of a total strength of Lok Sabha. This is right. Because in case of a coalition government or alliance government, more number of ministers might be included in the cabinet to satisfy those political party. In order to curb this kind of activities, the 91st Constitutional Amendment Act. 91st Constitutional Amendment Act was enacted to prevent this. The second one, the 42nd Constitutional Amendment Act 1976 introduced a ceiling on the maximum number of ministers in the Union government. This is incorrect because it was done by 91st Constitutional Amendment Act, not 42nd Constitutional Amendment Act. So the answer is statement 1 is correct, statement 2 is incorrect. And the 8th one, with reference to powers and responsibility of the Prime Minister of India, consider the following. They gave a 2 statement. The Prime Minister is vested with the authority to allocate and reshuffle portfolios among the members of the Union Council of Ministers. As we know already, Prime Minister is a prime. He is a first among them. So he can decide who has to induct and who has to relieve from the cabinet. So the statement 1 is correct. And the second one, all executive actions of the government of India are formally undertaken in the name of Prime Minister. It's not under the name of Prime Minister, it's under the President. So it is mandated Article 53 of the Constitution. So the answer is 1 only. First statement only correct. And the 9th question is, with reference to Union Council of Ministers in India, consider the following statement. Article 75 of the Constitution stipulates that Council of Ministers is collectively responsible to Lok Sabha. This is correct. Because of that, the main feature of a parliamentary government is executives are collectively responsible to legislature, unlike the presidential government, which is prevalent in many other states, especially in US, which is different, which means the executives are not responsible to the legislature. The second one is the doctrine of a collective responsibility. It is one of the elements of a parliamentary system. Collective responsibility require all cabinet ministers to abide by cabinet decision even if they held differing views during the deliberation. As we know, the cabinet is a prime of union government. Moreover, whenever they are introducing any bills or something else, beforehand they held an informal meeting in which if any minister have a difference of opinion regarding a particular act or any particular policy, they should abide by the collective decision of a cabinet. The third one, the president is not empowered to dismiss an individual minister if the council of ministers continue to enjoy confidence of Lok Sabha. This is incorrect because dismiss of an individual minister is based on the advice of Prime Minister. It does not include anything about the confidence of the Lok Sabha. So the answer is option B, 1 and 2. Tenth question, with reference to special provision to NCD, National Capital Territory of Delhi, consider the following statement. The Legislative Assembly of Delhi has a power to make laws, all subject that listed in the state list. As we know, there is a prime difference between the state and union territory is state has some degree of autonomous unlike union territories. Union territories are centrally administered territories. So in this respect, the state legislative power is not concurrent with the UT. Especially in the respect of Delhi, the police and law and order are not under the purview of a state list. So the option, statement 1 is incorrect. The second one, the maximum number of ministers in the Delhi Council of Ministers is restricted to 15% of a total number of members of a legislative assembly. This is also incorrect. This is not a 15%, this is a 10%. And the third one, in case of difference of opinion between Lieutenant Governor and the Council of Ministers, the Lieutenant Governor is obligated to refer the matter to President for the decision. This is also correct. The first and 2 is incorrect and the third one is correct because if there is a difference of opinion or conflict of interest between the elected government and the Lieutenant Governor, the matter should be referred to the President for the final solution. So the answer C, 3 only. In the 11th one, so the Attorney General must possess qualification necessary for appointment as a Judge of Supreme Court. This is correct because Attorney General is a chief legal advisor of a union government. So the Constitution prescribes certain qualification. He must be appointed as a Judge of Supreme Court. He must possess those qualifications to become a Judge of Supreme Court. The Attorney General is a full-time salaried employee of a government of India. This is incorrect because the Attorney General's salary is based on the number of cases he appears in the various courts within India. So he is not a full-time employee. The Attorney General has a right to participate in the proceedings of both houses of parliament but does not have a voting right. This is also correct because it does not possess any voting right in both houses, but he has a right of audience in both Lok Sabha and Rajya Sabha. So the fourth one, the Attorney General holds office at the pleasure of President of India. Like many other constitutional posts, the Attorney General does not have any tenure. He holds office on the pleasure of President. So the answer is A, 1, 3 and 4. The 12th one, Advocate General of a state. The previous one is a deal about Attorney General and this one is a deal about Advocate General. So Advocate General of a state is appointed by the President. This is incorrect. He is appointed by a Governor, not the President. So Advocate General of a state must have held the judicial office for 5 years or been an advocate of a High Court for 10 years. This is a correct statement. The Advocate General of a state hold office during the pleasure of Governor, parallel to Attorney General of Union. So Advocate General of a state term of office not fixed by the constitution, the same thing. The answer is only 3. Here the answer marked only 2, this is incorrect. The answer is only 3. Thirteenth question. In India, executive is collectively accountable to the legislature. We all know this is a collective responsibility basis of a parliamentary democracy. The Parliament of India function as a sovereign authority. This is incorrect. The Parliament does not enjoy a sovereign power. It is limited by judicial review and the constitution. So the statement 1 is correct. Statement 2 is incorrect. Option C. So the parliamentary sovereignty is depend on Britain Parliament, while the judicial supremacy is drawn in US Constitution. 14th question. With reference to institution of a pro tem speaker of India, consider the following statement. The pro tem speaker is appointed by President of India. This is a correct statement. The pro tem speaker is appointed to preside over the house when elections for the speaker and deputy speaker are yet to be held for a temporary basis. So the answer is both 1 and 2. The 15th question. Consider the following statement. The Speaker of Lok Sabha nominate panel of not more than 10 chairperson from among its members. This is a correct statement. The member from this panel preside over proceedings of a house during absence of both speaker and deputy speaker, both 1 and 2. While they are asking incorrect, actually these are tricky. In such a question we made a mistake. We should carefully read. This is incorrect. So the option is neither 1 nor 2. If you are asking which are among them are correct, mean both 1 and 2. They are asking incorrect. So option D, neither 1 nor 2. We should be more careful while dealing such a questions. The 16th one. Consider the following statement. A money bill related to taxation, borrowing and expenditure can be introduced only in Lok Sabha. This is a correct statement, because a money bill and such a things should be only introduced in Lok Sabha, not Rajya Sabha. The Rajya Sabha has an equal authority with the Lok Sabha in voting on demands of grant. This is incorrect. The Rajya Sabha does not enjoy this feature. Expenditure charged on the Consolidated Fund of India is subject to discussion and voting in the Parliament. This is also incorrect, because the expenditure charged on the Consolidated Fund of India does not subject to voting. This has to be done in order to ensure autonomy of a several institution, like maybe a Supreme Court and Election Commission and so on. So the option is option A, only 1. The 17th question. Which of the following reflect unitary feature of Indian Constitution? So the states in India do not have any right to frame their own constitution. This is a unitary feature. Unitary is opposite to federal feature. The amendment to 7th schedule can be carried out through joint action. So this is not a unitary, this is a joint action. So this is a federal structure, not a unitary structure. And third one, the governor is empowered to reserve certain bill passed by state legislature for the consideration of a president. This is a unitary feature. Comptroller and Auditor General of India is appointed by the President of India. This is also a unitary feature. The option is 1, 2 and 4. Option A. 18th question. With reference to constitutional procedure for formation of a new state. Formation of a new state, consider the following statement. A bill for creation of a new state by separating a territory from an existing state require period recommendation of a president. As we saw already, president is not only represent the union, he is also a representation. He is also representing the entire nation, including a state. So his period approval is prerequisite. So upon receiving such a bill, the president is required to refer the bill to legislature of a concerned state for its view. Exactly. So once the president receives such a proposal from the union of government, so they send to the concerned state, but the concerned state view expressed, which is not binding, which is just advisory nature like that. So option C, both 1 and 2. It's not binding. The 19th question, consider the following statement. The speaker decided on matter of disqualification of members under the anti-defection law, which deals with 10th schedule, anti-defection law. So, and such decisions are not subject to judicial review. This is incorrect because the decision is subject to judicial review. In the recent time, we often see that there is a much defection between in one party to another party. It exists both union and state. In this respect, we often saw there is a case filed in the Supreme Court regarding this. So this is incorrect. The speaker serves as an ex-officio chairman of a both Indian parliamentary group, which means this is a forum which represents Indian parliamentary in the international. So business advisory committee, yes, he is. So how? In which they are asking incorrect, not correct. Okay. In this respect, option A, one only, because this is not correct. This is asking incorrect. So 20th question, according to provisions of the Constitution of India, it is the duty of President to lay before Parliament which of the following reports, in which they gave 4 reports, which among them that necessarily lay by a President in the Parliament. The recommendation of a Finance Commission, yes, it is. The report of a Public Accounts Committee, this is a parliamentary committee, it does nothing with the President intervention, so this is incorrect. Report of the Comptroller and Auditor General and report of National Commission for Scheduled Caste. So the add-on is 2, in which they are asking how many of the above are correct, only 3, except the Public Accounts Committee. And then 21st, the 7th Constitutional Amendment Act 1956 and the State Reorganization Act 1956 were enacted on the basis of recommendation of which of the following committee? This is a direct question. It is Fasal Ali Commission. In the polity test first, we saw the hierarchy, which means periodical of constitution of this commission, in which they are asking based on the law. The Fasal Ali Commission is a correct one. The 22nd, with reference to Judges Inquiry Act 1968 for the removal of a Supreme Court judge, consider the following statement. The presiding officer of a respective house of a parliament may either admit or reject the motion of removal. Yes, it's depending upon the decision of a presiding officer either in Lok Sabha or Rajya Sabha. He can admit or reject. The President of India appoints 3-member committee to investigate the charges against the judges. This is incorrect. The committee is appointed on the request of Centre by President, not directly by President. The motion for removal must be passed in each house of parliament by an absolute majority. It's not absolute majority, which requires special majority. Special majority. So the answer is one only, option B. So 23rd, with reference to functioning and judicial calendar of Indian court, consider the following statement. The Supreme Court of India has more working days in a year for a judicial functioning than High Court. This is incorrect because High Court having more working days relative to Supreme Court. Only the Supreme Court has the authority to structure a calendar in accordance with the service rules. This is also incorrect. Both Supreme Court and High Court have their own power. Justice Malinath Committee recommended reducing the duration of court vacations in year. This is a correct statement. So option B, 3 only. We have again made a mistake. They are asking not correct. They are asking not correct. So the option is C, 1 and 2. Third one is a correct statement, but in this question, that don't. So 24, with reference to money bill in the state legislature, consider the following statement. When the governor reserve a money bill for the consideration of a president, the governor assent is no longer is required. This is a correct statement because when governor reserve a money bill for the consideration of a president, if president give his nod, it does not mean that the governor assent no longer required. So the second one, the governor cannot return a money bill for the reconsideration of the state legislation. This is also correct. So option C, both 1 and 2. Then 25th question. In the context of Union Budget of India, what does the term appropriation bill signify? The appropriation bill a bill that enables government to withdraw money from Consolidated Fund of India to meet both voted and charged expenditure. This is a direct question. Twenty-sixth question. With reference to no confidence motion in a parliament. It is no confidence motion in a parliament. Consider the following statement. The first no confidence motion in a parliament was moved in the year of 1991. This is incorrect because the first no confidence motion was moved in 1963 against Jawaharlal Nehru by J.P. Kripalani. J.P. Kripalani is a chief of Praja Socialist Party. It's a Praja Socialist Party. The statement 1 is incorrect. No confidence motion can be admitted when the minimum of 100 members support a motion in the House. It does not require minimum 100, which require minimum 50 is more than enough. A no confidence motion may be introduced either in the House of Parliament. As we know that the executives are collectively responsible to legislative, especially in the Lok Sabha. So, no confidence motion only introduced in Lok Sabha. It does not mean either House of Parliament. So, all three statements are incorrect. The option D is no. Then 27th question, with reference to panel of chairperson in the Lok Sabha, consider the following statement. The panel of chairperson is constituted exclusively from members of a ruling party. This is incorrect. Because the panel of members were drawn from various parties based on their majority in the Lok Sabha. A panel of chairperson is selected by Lok Sabha from among its members. This is correct. So option B, 2 only. Correct. Lok Sabha from among its members. So in which they gave neither one nor two. Actually, panel of chairpersons are elected by Lok Sabha from among its members. Panel of chairpersons elected by Lok Sabha, in which here they are not elected. Actually, they are not elected. They were nominated. They were not elected, they were nominated. This term is crucial. They were not elected. So option D, neither one nor two. So 28, with reference to Indian federal governance, which of the following commission recommended that the governor of state should be appointed from outside that ensure impartiality and detachment from the local interest, which means Sarkariya Commission. Actually, Sarkariya Commission was constituted in 1983 during the Prime Ministership of Indira Gandhi. 29th question, with reference to Zonal Council India, consider the following statement. Zonal councils were established under State Reorganization Act 1958. This is right. India is divided into 5 zonal council of administrative cooperation, for example, North, South, East, West, and Central councils. The Chief Minister of each state serves as a chairman of respective zonal councils. This is incorrect. Not Chief Minister, Home Minister of Union. Union Home Minister headed the zonal council. Recommendation of the zonal council are binding in nature. This is not a binding in nature. Recommendation of the zonal councils are just advisory. So option B, only 2. The 13th question, with reference to Northeastern Council, consider the following statement. It was constituted under Northeastern Council Act 1971 and functioned under the Ministry of Development of Northeastern Region. This is correct statement. The chairman of the council is the Union Home Minister of India. This is also correct. While the vice chairman were the Minister of Development of Northeastern Region, vice chairman. So option C, both 1 and 2. The 31st question, in the context of Indian politico-administrative framework, who hold the real executive authority? Here, the real executive, as we know, president is a nominal executive. They are asking a real executive. The real executive is the Council of Ministers headed by Prime Minister. Option D. And 32nd question, under the special constitutional provisions of Nagaland, Act of Parliament relating to which of the following matters shall not apply to state unless the state legislative assembly of Nagaland passes a resolution to that effect, which means that India is a asymmetrical federalism, which means some states have special provision with relative to other state, especially in the northeastern state, often called as the seven sister state. They have a various linguistic and cultural significance. In this respect, the act made by a parliament does not automatically apply to those states like our state, like Tamil Nadu and Karnataka. They have some special significance. So in this respect, they gave 3 heads: religious and social practices of Nagas, Naga customary law and procedure, and administration of civil and criminal justice. These three subjects, if even though the parliament make law on this subject, which require sanction of a Nagaland State Legislative Assembly. So option D, 1, 2 and 3, which means that enactment of these law by parliament does not automatically apply to Nagaland. So the next question, in the context of constitutional remedies in India, a writ of prohibition issued by the Supreme Court or High Court is directed to which of the following? This is a direct question. A subordinate court preventing from continuing proceedings in a case beyond its jurisdiction. This is a direct question. And 34th question. In India, some states have a bicameral legislature. Bicameral legislative is nothing but they have both legislative assembly and then legislative council. So they give 4 states. Among which of the following have a bicameral? So Andhra Pradesh have a bicameral, Maharashtra have a bicameral, Karnataka have a bicameral, Madhya Pradesh is a unicameral. So option only 3, option C. So 35th question, with reference to legislative council in state, consider the following statement. As per Constitution of India, the maximum strength of legislative council can be 250 members. This is incorrect because there is no fixation of a number of legislative council members. It depends on the 1/3 of the total number of legislative assemblies. So this is incorrect. 1/3 of members of a councils are elected by members of a legislative assembly of a state. This is a correct statement. So option B, 2 only. So 36th question, with reference to Lok Adalat in India, consider the following statement. Lok Adalat have been accorded statutory status under the Legal Service Authorities Act 1987. This is a correct one. Second, the award passed by Lok Adalat is binding on the parties and not appealable. Yes, this is also correct because Lok Adalat does not deal with the criminal, it deals with the civil procedure. So this is binding on both parties. Lok Adalat do not strictly apply procedural laws such as Civil Procedure Code and Evidence Act while assessing the claim. It mainly based on the natural justice. So based on the natural justice, so option D, 1, 2 and 3. Thirty-seventh question, consider the following statement. Criminal law and criminal procedure are subject listed under concurrent list of the Indian Constitution. As we know, both Union Parliament and the state legislative can make a laws in both criminal and criminal law procedure. If there is a contradiction between the Parliament and state legislature, Parliament law will prevail. The Bharatiya Nyaya Sanhita define criminal offences and prescribe punishments for them. This is also correct. The Bharatiya Nagrik Suraksha Sanhita categorizes offences into types such as bailable and non-bailable. This is also correct because the Bharatiya Nagrik Suraksha Sanhita define types such as bailable, non-bailable, and then cognizable, non-cognizable, and compoundable, non-countable. These are types of offences. So option D, 1, 2, and 3. The next question, the bill seeking to amend the federal provisions of the Constitution must be ratified by at least half of the state legislature. This is correct. Because if any bill or a legislation or act which affect the interest of a state, that should be ratified by at least half of the states. Both Parliament and state legislature are required to pass such bill by special majority. This is incorrect. A Parliament can pass such a bill special majority, but state legislature can pass the bill with a simple majority. Amendment of Article 368 itself considered a federal provision. Yes, it is also correct. So option A, 1 and 3. The 39th question, with reference to imposition of a president rule under Article 356, consider the following statement. A proclamation for imposition of a president rule cannot be declared when the Lok Sabha is not in session. This is incorrect. Because usually president rule imposed on the state when the constitutional machinery of the state failed. So we cannot expect that does occur only when the Lok Sabha is in session. So the second one, a resolution approving the continuation of a president rule in a state can be passed by Parliament by simple majority. Yes. This is a correct statement. So answer B, 2 only. The next question, which of the following statement regarding the concept of office of profit under Indian constitutional and electoral law is incorrect? They are asking which one is incorrect. The term office is not defined in either Constitution of India or Representation of the People of India, while it is defined. The second one, holding office of profit is a valid ground for disqualification under the Representation of People Act. This is also correct. An office under central government that carries a non-compensatory. This is a non-compensatory, which is different from compensatory. Although qualifies as an office of profit, merely acquiring a government issued license to perform a certain function among holding office of profit. This is the correct answer, because government issues some license for running education institution or something else, we cannot amount that as a office of profit. The next question, consider the following statement. Under the collegium system, the Chief Justice of India alone, this is important word, he can alone, CJA alone recommend the appointment of judges. This is incorrect. Because collegium is refers to colleague, which means group of judges, not CJA alone. A High Court collegium is headed by incumbent Chief Justice along with the two senior most judges of the court. This is a correct statement. Collegium system is not mentioned in the Constitution. Yes, it's not mentioned in the Constitution, but has evolved through Supreme Court judgment. There is a judgment called the 3 judges cases through which the collegium system evolved. The 99th Constitutional Amendment Act established NJAC, National Judicial Appointment Commission. It was later struck down by Supreme Court as it affect independent of judiciary to strengthen the collegium system. It's not intended to strengthen, it intended to replace the collegium system. This is also incorrect. While which of the above statements are not correct, they are asking option 1 and 4. Option A, 1 and 4. And then next question, with reference to concept of delegated legislation in India, consider the following statement. A delegated legislation refers to process by which Parliament entrusts certain functions to subordinate legal authorities, including specification of operational details. This is a correct statement. Delegated legislation is excluded from the definition of law under Article 13 of the Constitution. This is incorrect because if Parliament delegated any function to someone who performed the function, if the function affected or violated the fundamental rights, that's under the purview of a judicial review, Article 13. So the answer is one only. Then next question, with reference to ordinance making power of a president under Article 123 of the Indian Constitution, consider the following statement. The president power to promulgate ordinance is parallel form of legislation alongside Parliament. This is incorrect because Article 123 is a special power of a president to promulgate ordinance that should be done only during the recess of a Parliament. It's not parallel to legislation of a Parliament. This is incorrect. The power to issue ordinances is discretionary power of a president which may withdraw at any time. This is also incorrect. Because the issue ordinance is not a discretionary power of a president, it should be done by aid and advice of Council of Ministers. So every ordinance promulgated by the president during the recess of Parliament must be laid before houses when they are reassembled. This is a correct statement. It should be done so that to ensure the proper legislation. So the option B, 3 only. The next question, accession and recent type. 0 hour is not mentioned in the rules of procedure of Parliament. Yes, it is. Reason, 0 hour allows members of a Parliament to raise urgent matters without period notice and is an Indian innovation in parliamentary practice. This is also correct. So option A, both A and R true. R is a correct explanation of A. The next question, the point of order is extraordinary device used to suspend the proceedings of the House. This is incorrect because the point of order is it's a legislative tool to ensure the proper functioning, proper order of the function of a House. It's not suspend of a proceedings of House. Reason, a point of order is raised when House does not adhere to its established rules of procedure. This is a correct statement. So A is false, R is true. Option D. Next question, which of the following factors act as a limitations on the sovereignty of an Indian Parliament? Which act as a sovereignty of an Indian Parliament? Fundamental rights enshrined in the Constitution. This is also correct because if Parliament make any act which violate the fundamental rights, which is struck down by a Supreme Court, this is. So option A is correct. The federal structure of the governance, this is also correct, which make the limitations on the Parliament because in the federal system the power is clearly defined between state government and central government, and there is another is concurrent, so which plays a hindrance on the Parliament function. The third one is system of judicial review. Judicial review also impose limitations on the Parliament because Parliament cannot make law as its own wish. The law made by Parliament does not affect basic structure of the doctrine, which is it is defined by judiciary. The fourth one, the written nature of the Constitution. This is also correct because the Parliament should adhere the Constitution which is in the written form in India. So the option D, 1, 2, 3 and 4, which all make limitations on the Parliament power. The 47th question, with reference to powers of Supreme Court under its original jurisdiction, consider the following. Dispute between Union government and one or more state, this is the original jurisdiction of the Supreme Court. And the dispute between two or more states, this is also original jurisdiction of the Supreme Court. disputing arise between the union government and the union territory. This is not it's not come under original jurisdiction of the Supreme Court, because union territory more or less are administered by central government, so it does not come under the original jurisdiction of the Supreme Court. Dispute relating to elections to parliament and state legislation, this is also not a original jurisdiction of the Supreme Court. If any dispute arising regarding the state legislation or parliament, we can approach to courts, not necessarily Supreme Court. So they are asking which of the above are explicitly under Article 131 is option A, 1 and 2. First two only are under original jurisdiction of the Supreme Court. The next question, consider the following statement. A state government may borrow within India, but it must seek the prior consent of the central government if it has any outstanding loans from the center. It's dealing with the borrowing of a state government. So this is a correct one. The state government is permitted to raise loans using the consolidated fund of a state as a security, which the state government can pledge its consolidated fund of a state as a security. So this is also correct. So option C, both 1 and 2. Forty-ninth question, with reference to writ jurisdiction of the Supreme Court of India under Article 32, consider the following statement. The writ jurisdiction of the Supreme Court in matters related to fundamental right is exclusively. It's not exclusively, this is incorrect, because Article 32, Supreme Court can issue a writ. Under Article 226, High Court can issue a writ jurisdiction. So this is a concurrent, not exclusive. So the second one, the President of India can confer upon the Supreme Court the power to issue writs for the enforcement of ordinary legal rights. This is also incorrect. The writs is based on the Constitution. So the answer is D, neither one nor two. Both are incorrect statement. The next question, with reference to State Administrative Tribunal in India, consider the following statement. The establishment of a state administrative tribunal can be initiated solely by respective state government. The appointment of a chairman and members of a state administrative tribunal is made by governor. It's not made by governor, it's made by president. Made by president. And the establishment of a state administrative tribunal can be done by union government, not a state government, because state government can formally submit its report, but the initiative is solely on the basis of union government action. So in which both are incorrect. So option D, neither one nor two, because the appointment of chairman members of state administrative tribunal is made by governor with the consultation of CJI and governor of a respective state. It's not chief justice of a concerned high court. The next question, which of the following statement correctly describe the process of conciliation under the system of alternative dispute resolution area? So in which a voluntary and non-binding process where a neutral third party assists the disputant in reaching mutually acceptable settlement. This is a very basic question, anyone can answer easily by reading this. Next question, consider the following statement. The president rule can be imposed on the grounds of failure of a constitutional machinery in the state. This is a correct statement. The second one, it is a duty of a center to protect every state against external aggression and internal disturbance. This is also correct. So both statement 1 and 2 are correct, and the statement 2 is a correct explanation of the statement 1, option A. Consider the following, in which they gave 5 lists. How many of the subject mentioned in the above are transferred concurrent list by 42nd Constitutional Amendment Act? As we know, 42nd Constitutional Amendment Act as a mini constitution, which is called as a mini constitution as it contained more articles. It was enacted in 1976 during the Prime Ministership of Indira Gandhi, during the prime ministership of Indira Gandhi, especially in the emergency period. So, in which 5 subjects are transferred to the concurrent list, which including education, forest, protection of wildlife, and ways and measures, and then administration of justice. Administration of justice. These are the 5 lists that